My name is Kurt Von Kahn, and I'm an arbitrator and mediator at JAMS. Before I joined JAMS, I went to Harvard College, 2 years in the Army, Harvard Law School, 16 years of private practice as a trial lawyer, 10 years as a trial judge, and then in 1997 I joined JAMS as one of the founders. I was on the first board of directors and the National Arbitration Committee. My mediation style is collaborative. I recognize that the lawyers know much more about the case than I ever will, so I work with them to try to identify what are the obstacles to settlement, and then develop with them a plan to deal with those obstacles. For an arbitrator, the hallmarks of a successful arbitration are producing an award which makes it clear that you thoroughly understood and reviewed the parties' positions, and you reached a judgment that is rational and supported by the record. Now, for an advocate, the three most important are probably prepare thoroughly, throw away weak claims and defenses, and never impair your credibility with the arbitrator. I like business-to-business cases with complex legal issues, and that can be any number of things. Neutral evaluation work is what judges do day in and day out. I think any judge who is smart and willing to put in the time and effort to really study the record can do a good job at neutral case evaluation, and I do it very thoroughly. But I have a special interest in the arbitration process and trying to make it more cost-effective and expeditious. I served for a while as editor-in-chief of the College of Commercial Arbitrators' Best Practices Guide, which focused on that. And then when I was president of the college, I convened a national summit on business-to-business arbitration here in Washington, which resulted in protocols for a more expeditious, cost-effective arbitration, and the protocols won awards from the ABA and CPR. I think perhaps the thing that differentiates me from other ADR professionals is that these days many are specialists. They only do employment cases or construction cases or healthcare. I find that that is not as stimulating for me as having a wide variety of cases. It gives me a chance to study and try to figure out a new area of law. And for me, that is exciting and energizing. And it does have a benefit, I think, for the parties. I had one case where I told the parties, I've never done a Superfund allocation case before. And they said, great, now you approach it without any preconceptions or any fixed views.